Okay, so I think we are all ready, and some of us have been here until since this morning when we had the wonderful PhD defense of Mara Moldoveanu. Congratulations once again, Mara. She is the first student to graduate here in a joint supervision from the Reader Lab, having myself as a supervisor and Henry. And we thought that given the unique opportunity of having him here, hopefully just the first from a series, we would just want to learn a little bit more about the research in your lab. I have had the pleasure to take part in a couple of your meetings, and it's a very intellectually stimulating atmosphere. Here are some of our students. Some of them are in the first year, so they will just learn a little bit of some topics of interest. Some of them are in their second, and also some colleagues who might be around also for the discussion afterwards. We invite everyone afterwards in Sala 19 to learn a little bit about some research in deception. So first of all, I will give the floor to you, and don't hesitate if you have questions or just to start the dialogue. So thank you very much for being here.
Thank you, Laura. Can you all hear me? Yes, I don't need a microphone or something. Okay, great. Well, first of all, thank you for giving me the opportunity to say some words about the research I am doing. And also thank you, Doctor, she's now a doctor, so I have to call her a doctor now. So I was asked to say a few words, to present some stuff about the research that I'm doing. And I was thinking about what can I present. And the one thing that I would find interesting is a very fundamental issue, which is the issue about psychology and the courtroom. So I'm not sure if you know, I work as a professor of psychology and law at the psychology faculty at Maastricht University, but also at the law and criminology faculty at the University of Leuven. Two different universities, two different faculties. They have a different culture, they have a different background, different traditions. And I try to bridge the gap between psychology and law. So one of my main interests in terms of research is, for example, wrongful convictions, people who have been sentenced to jail while they are innocent, or the reliability of testimony, interviewing witnesses, etc. And because of that work, I'm quite regularly asked to be an expert witness by, for example, the courts, or by a lawyer or a prosecutor. And this goes very simply like this. They call me or they send me an email and say, well, Henry, we have this case here, can you help us? And for example, they have a case and they say, well, this is a person who says that he is in prison but he's innocent. Can you perhaps look at this case, maybe with your team, and perhaps say whether there is some grounds that this person has been wrongfully convicted? Even this morning, I was involved in a case, and people asked me about a case in which they wanted to know what drugs does with your testimonies. I'm not sure how it is in Romania, but I'm from the Netherlands, and drugs is unfortunately very easy to get. So there's a huge concern that people use it, misuse it, and that it might affect their testimonies. And people want to know, so how can it affect your testimonies, etc. Then the basic question is, can we really use the psychological knowledge that we have for the courtroom? Can we do that? I will say we are already doing it. We're doing it for many years, but maybe we have to take a step back and think about whether we are doing it in the best possible way. And I think this colleague, George Miller, is one of the first, I think, who really came up with a very important statement about what psychology can offer to society, for example. Because if you use psychological knowledge for other purposes, for the courtroom, or maybe for therapeutic processes, helping people or society, you're using that knowledge to hopefully help people, for example, in court. And he said the following during the presidential address: I believe that the real impact of psychology will be felt through its effects on the public at large. So I've made this a little bit in purple, public at large. So according to Miller, it's the effects of psychology, you can see it if it makes an effect on public, maybe in other contexts, such as the courtroom, for example. But is it? Is psychology really ready to be applied in the courtroom? So this will be the fundamental issue I'm going to talk to you about today. It is very fundamental. So some of the stuff that I'm explaining, I will try to explain it in the most basic possible way. But it's so fundamental because some of the students here, you're reading articles, and some of that stuff is being used for all kinds of purposes. And so it is good to perhaps reflect on when you might use it or when you might not use that knowledge. One expert witness wrote about what she called fragmented memories of trauma. So she said these children recalled abusive acts by the teacher, not in a coherent way, but in a fragmented way, incoherent. So which means that the children were unable to speak and talk about what happened to them in a very logical way. And she says that's a sign that they perhaps indeed were abused, because according to this expert, fragmented memories of trauma, that's a common reaction if you're traumatized. So this statement that this expert gave, this psychological expert, implies that this topic of fragmented traumatic memories is well established and can be used in court, because this is what the expert talked about. And if you do that, then people in court, judges or juries, depending on which jurisdiction you're in, might accept this with face value. But is it? Is this really a well-founded statement? So there is a meta-analysis. There's a meta-analysis showing traumatic memories lack coherence, so are fragmented. But actually there's a huge debate in this field on whether traumatic memories are coherent or fragmented. This is an interesting paper by Richard McNally, Are Memories of Sexual Trauma Fragmented? This is a paper from Andrea Taylor and colleagues that traumatic memories are not fragmented. This is a paper by this guy Henry, who says that these fragmented memories, these come very close to the idea of repressed memories, which is also very controversial. And there's a recent paper, also by Andrea again, also saying that traumatic memories are actually quite coherent. So wouldn't it be better for the expert to give the full picture, to say, well, we see some fragmented testimonies here, might be caused by trauma, but I have to admit there is a huge debate in this field about fragmented memories of trauma. In my perspective, that's what the psychological expert should have done. So I already told you I played a role in this case. So there were two expert witnesses. I was the third expert witness, and I came in play because of the following. One expert said these testimonies of these children, they are valid, they are reliable. These children really experienced something in that class which was likely abusive. And there was another expert that said, no, these children's testimonies are likely false. So that's very difficult for a judge then. Oh, damn, what should we do now? Did this person, this classroom teacher, really do something or not? And then he said, Henry, can you look at this again? And I said, no, I cannot do it again because I was already aware of the case. I knew the case, so if I would do it again, I would have been biased, right? I knew that this case was already in the media, and I knew some of these experts, and they have been talking about this case. I said, I know I cannot do it, but I can do another thing. Together with my team, of which some of them have no knowledge about this case at all, I can look at the expert witness reports, and I can see and examine how they wrote these reports and whether they are indeed a little bit based in scientific evidence. Then I found this, that one of these psychological experts talked without reservation about fragmented memories of trauma, and in my perspective, I would have given it a more cautious approach. So what can expert witnesses and legal professionals testify about when it comes to psychology in the courtroom? And maybe some of you who have an interest in psychology in law or forensic psychology, and you might start working in this field, you might be asked maybe to do some stuff with the psychological knowledge that you have. And I will give some examples in Romania that this is already being done. So and the question is, what can we really do? So it is a timely issue. that the involvement of expert witnesses in courtroom, but also that people criticize it. So this case is the Ghislaine Maxwell trial. You know her? Some sort of partner of Epstein, and she has been recently re-interviewed again because maybe concerns of the Epstein files and the involvement of maybe Trump, etc. Anyways, do you know who the person at right is? I mean, my colleagues guess know it, but I'm not sure if the students know. Do you know who this person is? This is, if you don't know, it is a problem as a psychology student, because I would say it's good to know who she is. This is, I would say, maybe one of the most famous psychologists that we now have. I'm, again, super biased, but her name is Elizabeth Loftus. And she's this big pioneer in the field of, I would say, eyewitness memory, eyewitness testimony. And she's still very active. I think she's in her 80s. Very nice person. And she is asked a lot for these type of cases. So then they ask, for example, Elizabeth Loftus, and they ask, well, is it possible that the case of Ghislaine Maxwell and Epstein is about young girls coming forward with that they were mistreated, abused maybe by Jeffrey Epstein and others, and then they ask Elizabeth Loftus, could this perhaps be a false memory, or is there no reason to believe that these are false memories? And then what she then often does is that she uses psychological literature to investigate whether these claims of these women in this example, whether they are true or false. And then you see the following. Then she has been criticized a lot. She uses, for example, a lot of research. One of her studies is called the Lost in the Mall study. And people say, well, that study, that's not good evidence for false memory of rape. Or here, my comments really are about that Elizabeth Loftus misappropriately uses the memory distortion literature. So people are criticizing whether she can use that literature in court. Or Elizabeth Loftus is overgeneralizing the literature in court. And there are indeed psychologists like Chris Bruin that there is, and there are also other colleagues I will show you in a bit, that say that our field of psychology also has some sort of generalizability crisis, which means that some of the stuff that we do research on in psychology and law, the question is whether we can generalize that to specific cases in court. So to make it very clear, if we do research with students, like some of you students, and how your memory works, and we write a paper on it, we try to publish it, and then we are involved in the case, can we use the results of that paper to make some claims in court? Can we do that? The answer is people are already doing it, but my question is, can we actually really do that? And I think you already know the answer. No, we cannot. That easy. I don't think we can do that. And there's also a timely issue in Romania, because Romania has a very interesting legal system also, and a lot of interesting involvement of psychologists in court. So there are some known wrongful conviction cases in Romania. So people who have been sentenced to prison and later was found out that they were innocent. This, I think, is one of the oldest one. I will not try to pronounce it, right? So I'm not doing it. But this already happened in 1977. And this is a case of false confession in which someone was sentenced to jail, confessed to a crime, and it became clear that this person falsely confessed to this crime, likely because of intense police pressure. Here's another one. Marcel, I think I can pronounce that name. Marcel, 1992, a case likely about a false accusation case, also in which a person was wrongfully convicted. Or this one, Visan, I will do the last one, I'm not sure what the first, a false confession case as well, 1994. And why do I show this? Because these are cases in which one of the contributing factors for these wrongful convictions were psychological factors, psychological reasons, right? So then you already see how important it is for psychologists to be involved in legal cases. They can help triers of fact. They can help judges, juries, prosecutors, lawyers with a case. And I mean, there's a recent paper talking about criminal proceedings in Romania, achieving judgment by means of forensic science during the criminal proceedings in Romania. And in this paper, they talk about forensic science in the broader sense. So they also talk about forensic psychiatry, forensic odontology, etc. And one of the conclusions that they say is that people in court, judges, they lack understanding of forensic science. And that's why they will ask people like psychologists to help them. They lack the understanding how things work in the forensic area, and they might need a psychologist for this. So in Romania, it seems to be also very important and timely that, for example, a forensic psychologist or a legal psychologist is asked. And in that paper, you see that what sometimes these forensic psychiatrists then do, then they, for example, do a psychological examination, and they look at all kinds of different issues and decide whether or not something is wrong with maybe a suspect or not. This also, I found a very, I don't know the journal, but I found a very interesting paper. This was about a criminal case, a civil case, in which they examined minors, children, using projective tests, and to examine what was going on. And you're laughing. You know the persons?
A little bit.
Okay, good. and okay, so anyways, so this, for example, was the children had to draw this, a family drawing, and this was used in court also to explain how the family dynamics went, whether maybe there was some form of maybe some negativity in the family. I'm telling you now, these tests cannot do this, but they are being used. They're used in court, or it's at least used for making decisions in court. I would say it like that, maybe even better. Can we do that? Can we do that? I don't think so. Is psychology ready then for the courtroom? I could say no, and then we can stop. But I think, of course, psychology is, we can make it ready if we, I think, adopt a little bit more cautious, transparent approach, which I want to talk to you about. So what I want to do in this talk is what can we reliably say about psychology, and maybe give some sort of guide for people working in this field. And this is a guide which is not perfect, not at all, and that's also not my intention, but at least a way to think about it. So let's go back in time a little bit, think about who were the first people who really said something about the involvement of psychology in courtroom. And I mean, this is certainly one of the persons, legal professional, John Henry Wigmore, who supposedly said this: when the psychologist is really ready for the courts are ready for him. People say that he stated this in 1940. I've tried to trace this exact quote of him. I have never found it, but a lot of people say that in other papers that he said this. I can never find the original source. Likely. Sorry?
After he destroyed psychology.
Oh, probably. That's the thing. Yeah, probably indeed. He hugely attacked Münsterberg as well, etc. So yeah, another legal psychologist. But let's say he did say it, and that's just my fault, I cannot find it. He already talked about whether the courts are ready for psychology. And if you look in the 1960s, 1970s, sorry, sometimes you see some red markings, these are just from me. Scholars have discussed the involvement of psychology in the legal arena. They talk, for example, about how an expert witness should be in court, what an expert witness can do. So, for example, they can, for example, talk about whether a suspect has been lying, whether an interrogation has been, from the police, has been suggestive, whether children have really experienced something. So already at that time, there were scholars who were interested in this. And here you, for example, even have people talking about whether this research of legal psychology, whether this research is external valid. Can we really use that research for external situations? Already then, people have already talked about this. And here you have Elizabeth Loftus, who already said that 10 years in the life of an expert witness. And here, right above, I think it's Elizabeth Loftus, but I think they miss Loftus, another one, but I think it's Elizabeth Loftus. So she already talked a lot about her involvement as a psychologist in court. I'm not sure if you know how she started in this field. She was not a legal psychologist, of course, when she started. She was actually very interested more in what she perhaps could call mathematical psychology, trying to find some universal rules to explain behavior. And she had, of course, interest in cognition. And then there was at a certain point someone who asked her if she could say something about whether testimonies of witnesses, whether they might be true or wrong. And then she looked into the literature and could not find any research really on this topic. That's how her career started, and it's a huge career what she made, a very important stuff that she did. If you look at 2000, and now you have in many different countries, also including the Netherlands, a lot of papers on how psychologists, what type of statements they can make in court. We recently, even together with Annelies Vredeveld, you can see below, we even created a paper in the journal Psychology, Crime and Law with guidelines on how legal psychologists or forensic psychologists should write reports. Because if there's one thing that I've seen is that if we as psychologists, if we do a study, an experimental study, there are some strict rules on how to do it, that you have a lot of control, that are not confounding variables. There are also strict guidelines on how to write this paper up in a manuscript and hopefully to get it published. And what the weird thing is, at the moment that these same psychologists are then being asked to appear in court, the way they write reports differs immensely between expert witnesses. I've seen reports, and I'm not going to give any names because my early reports were certainly bad as well, but I've seen reports from experts as some sort of free association, and some were super structured. And I think because in some of these cases, what these experts say is used by judges. I think it's important that we as psychologists use the same high standards when we write reports. And that's why my colleagues and I at least came up with some guidelines on how to do that. If you then look at the type of papers that have been written about psychology in courtroom, then you can very broadly categorize them, like papers about experiences as an expert witness, papers on whether some type of evidence is admissible or not, forensic psychologists, for example, about whether a person needs to have treatment or not, a person who has committed a violent crime, guidelines on reports, or case studies. And here you see some specific examples of expert witness work related into the field of testimonies and memories. So I'm not sure if you know Willem Albert Wagenaar. Unfortunately, he's not alive anymore. But I'm super biased here, but Willem Albert Wagenaar was a Dutch legal psychologist. But if you're interested in this area, read his papers. It's unbelievably still timely for now. The way he thought about psychology in courtroom, I think, wow, damn, that's state of the art, still state of the art. And to give a good example, he was involved in the Demanu case, a case in which Elizabeth Loftus was asked, but because of, if I'm correct, her Jewish origins, she didn't want to do it. So it was, I thought, a World War II case, and Willem Albert Wagenaar took the case. That's also why he became quite famous in this area of expert witness work, and did an unbelievably interesting and good job as an expert. If you look at all of these papers, I don't, in general, see no statements, reflections on how strong psychological research is to be used in a courtroom. Oh, that's not what I want to have. Yeah. I also don't see any guidelines on how to use scientific research and how you talk about it in your reports. Because here is the problem. I think this is the problem that I think underlies this issue. Right? So as many of you are students, you read a lot of interesting papers, and maybe some of the stuff that you read might be picked up by psychologists and use it in their reports, and these reports are used in court. And I think this is the problem. So let's say you are discussing a certain psychological phenomenon, but you don't know whether this paper that you are reading, if that's the only paper in this field, or that many others have replicated as well. And if you don't know it, and if a certain phenomenon has not been replicated, has not been found again, can you then use it in court? Or if you are reading a paper on students in Romania who, through suggestive questions, formed weird memories, and you use this paper for a case which is on students in Indonesia, can you use that research? Can you? It's a question, but I'm not giving an answer. Can you do that? And even if you have that, if you have that research, how relevant are these papers that you read for certain cases? So, in my perspective, I think if you are engaged in doing work for the courtroom as psychologists, these are perhaps some aspects you need to consider when writing reports, when being involved in these cases. So that's what we're doing at this moment. So, for example, we recently wrote a paper, this was specifically about memory. What can expert witnesses reliably say about memory in the courtroom? And we said, I think it's important for expert witnesses to be, to look at whether stuff that they write upon, whether this has been replicated. Is this only one study that you're referring, or are there multiple ones? Can you generalize it to the specific case? How relevant is a certain paper? And we said, well, that perhaps are three conditions which might be important. So we made the claim psychology can only meaningfully contribute to court when the findings meet these three conditions: replicability, generalizability, and practical relevance. So I'm not sure if you're aware of, I think of our scholars as well. There have been, of course, concerns about whether some effects in our field can be replicated or not. And some can and some cannot. And there can be various reasons for why studies cannot be replicated. I think the way I was, when I was a PhD student, I think the way we could do our research was a lot, we have more degrees of freedom than if you now do research. And I mean, for example, we did a study, we have data, and we could do all of the analysis that we wanted, and only wrote the analysis that we thought were interesting, knowing now that was not very good practice. So this could be a reason, for example, why some studies, why some findings cannot be replicated. And this is something that people have also been writing about in the courtroom. Jason Chin is someone who has written a lot about this, about psychological science replicability crisis, what it means for science in the courtroom, and how you can improve the credibility of such research. I think replication is an important one. If you talk about psychology in the courtroom, make sure perhaps that you're talking about phenomena that have been replicated, and if they have not been replicated, disclose that, so that at least people in court can know how strong this research is, or perhaps is not yet. There's some other research by Jason Chin on replicability, and also in criminology, how this is being viewed. I think these are important aspects for the field of psychology and law. Here's a good example. I mean, I'm involved sometimes in cases in which the person goes to therapy, has mental health problems, does not have any memories of trauma or something, but that in therapy, the therapist says, well, you have mental health problems. That could be because you have these repressed memories of trauma. I will put you under hypnosis or something, and suddenly this person recovers a memory that he or she didn't have before therapy. And there is a good, the hypothesis could be that these memories are not real memories, they are false memories. They are induced by the therapist. Not willingly, could be that the therapist really believes that this is a good therapeutic practice. And we see, for example, in the Netherlands, I'm not sure if you have this here in Romania as well, there's one specific therapy called EMDR. Have you ever heard of this therapy? In the Netherlands, it's the #1 therapy for trauma. So the therapy is followed. Before I continue, this is a therapy which has received empirical support. There are a lot of studies, meta-analyses. It works. It is a therapy in which people go to therapists, they have to retrieve their most traumatic image of the event, and during the retrieval, the therapist, for example, moves her or his index finger in the visual field of the patient, the client, which the person needs to follow, and that what studies have shown, if you do this dual task, the vividness of this traumatic memory and the emotionality of that traumatic memory declines, is reduced. Okay, so and we see in many studies that this indeed is the case. However, we see unfortunately also a lot of cases in which people don't have any memories before going into therapy and going into EMDR therapy, and suddenly get memories of which the question arises, are these perhaps false memories? So we thought, you know what, we investigate that. And we found evidence. Lateral eye movements, these are the eye movements that they have to make, we found that they increase false memory rates. Interestingly, would be interesting also for court, but here other colleagues from the Netherlands could not replicate this effect. And they said lateral eye movements do not increase false memory rates, a failed direct replication study. I think this is important also that someone could not replicate it, because it means that as a psychologist, you cannot now say, well, yes, this is a very strong finding. And interestingly, I know that Sanne Hoebe, that's the author of the first study, and Kevin, who you see in the second study, they were both in a symposium, which was about trauma and memory, etc. And they wanted both to present this, but Kevin eventually could not make it at that symposium. And I think there was a good decision, and I think also a very proud decision, that Sanne said, you know what, I'm going to first present my own study in which I find it, and Kevin, you know what, I'm going to present your study as well in which you don't find it. I thought that's good practice, right? Because that shows also good attitude, that you're not attached to that finding. And she presented also the study of Kevin who couldn't make it. Of course, the question arises, why do we still see people getting these memories in EMDR? We don't know yet. We're still investigating this. We have the unique opportunity at this moment that we can look at special police files in the Netherlands, which in some of these police files, these victims went to EMDR therapy, then got these memories, and we're looking at what happened with these statements. Did they already have memories or not? We will see. So that's a little bit about replication issue. Another issue is about the generalizability crisis. I can tell you there is debate on whether we really have a generalizability crisis. Talia Arconi says we have. Other colleagues, maybe Daniel Lakens, are more critical towards this. But I think for our field it is important, certainly, if you, for example, do research on word lists, lists of words, to investigate how well people remember these words, and you're going to use these findings for cases in which people have rich autobiographical memories of trauma, of abuse, can you do that? You might, maybe, or should you be very careful and look for studies that share some of the conditions that of the case that you're interested in. And also here, if you look at the field of memory, people have already been discussing this already for some years. So I do, some of my colleagues and I, we do research in the area of false memories, people remembering events, details that you did not experience, and you can do that in various different ways. But these false memories, they don't seem to be very related to one another. They seem to be caused by different mechanisms, maybe even. So you should be very careful if you have a certain case on, for example, autobiographical false memories, to use research in your expert witness report about false memories of, for example, words. And I think already 2007, 2005, people have been talking about this. Not only in the field of false memory, also in the field of false confessions, or eyewitness identification, so in which an eyewitness needs to identify whether a certain person in a group of people is the perpetrator they thought. There are concerns on how generalizable the result of the studies that we use are in real life. Another concern is that a lot of research in our field of psychology is conducted in what they call weird countries, Western educated, industrial, rich and democratic countries. And this is a question, can you use results from Dutch participants to make claims about Indonesian participants, for example? Why I use Indonesian is because the Dutch have a very difficult, special relationship with Indonesia. I just talked to one of your colleagues that the Dutch are, how do I say it politely, are famous and infamous for their colonial adventures. And my family is half Indonesian. And I'm half Indonesian. No, my family is Indonesian. I'm half Indonesian. I have a special relationship with Indonesia, and almost every year go back to Indonesia to my family. Some research stuff I do there as well. And what is interesting is, for example, the following: we do quite some research on how to interview children who might have been. Might have experienced something traumatic. They might have been abused by, for example, a family member. And there are all different ways in how you can interview these children. So, and these ways on how to interview children, they have also been translated in other languages, for example, Indonesian language. So I'm not sure, let's say 6 years ago, we started with this research also in Indonesia. And one of the first steps was, let's translate this English and also Dutch interview protocol in Indonesia and see if it works. And we were so naive that we thought we could use this research immediately for Indonesia, but we couldn't eventually. So, for example, in Dutch and in English language, if you want to talk to a child, one of the most important questions that you need to ask are questions like, tell me what happened, tell me more. So you ask children to give a detailed narrative. If you translate that to Indonesian language, you get something different. You don't get tell me what happened, you get just tell me a story, which is a different type of meaning in which children might get the impression that they can just tell a story, whether it's true or false doesn't really matter. So these cultural dimensions and these cultural differences might be extremely important, something that was discussed during your defense as well. And indeed, there are quite some interesting papers about the cultural foundation of human memory. Chi Wang is a very important researcher, I would say, who has done a lot of research on different cultures and how they encode and retrieve memories differently. And there's this recent target paper in the journal Legal and Criminological Psychology in which different scholars, including us, discuss these cultural aspects in psychology, and specifically psychology and law. And Patricia Bauer, she was the former editor of the Journal of Applied Research in Memory Recognition. She also had this very interesting paper she wrote, which is called Generalization, the Grails and the Gremlins, in which she a little bit criticized some of the memory research. And she said in much of the memory research, people have used restrictive, non-representative samples, that there are issues on how to measure, for example, memory. Do you really measure memory, or are you measuring something differently? That the stimuli are often totally not related to people's experience in daily life. And she said that people have an over-reliance on mean differences in these studies, etc. Well, you could disagree with it, but what I just wanted to say, that people have been writing about it, thinking about the type of research that we do and what that tells us about generalizing these findings, for example, to court settings. Another thing that is important is how relevant and practically relevant or meaningful our research is. So I think many of you are educated in more quantitative type of methods, maybe experimental methods, in which statistical significance is something that you have been learning about, which is not the same as practical relevance. So some people might think that just because I find something significant, it immediately means it's also relevant and meaningful in court. And I think scholars are increasingly saying that that's not the same. Could be, but not the same. And they're advocating for that if you do research, you should think about effects that really matter in your field, that are the smallest effect that really matters in your field. I will come back to that, what that really means. So this is the smallest effect that you maybe as a researcher care about, that might be theoretically relevant or practically relevant. I think also, I talked about him already, Daniel Lakens has done a lot of research, studies and writings about this. And I think it's an interesting concept to think about in the area of psychology and law. And the smallest effect can differ depending on the context and depending on the field of psychology you are in. For example, let's say you are a traffic psychologist and you are interested in whether using your mobile during driving might be dangerous, right? And I have to admit, I sometimes do that too, but although I know it's dangerous. But anyways, let's say you want to do an experiment on this, and you have then one group who drives a car and at a certain moment can use the phone and then maybe look at an email, and you have another group of participants who's not allowed to do that. And your dependent variable is if you move your car to the other road, the other side of the road. Which difference would be relevant? I could say that even if you would cross the road, I mean, that is just people can disagree, but I could say maybe if you already would cross the road with 1 centimeter, that is relevant because 1 centimeter could be enough for the other car to hit you, which could end up in a huge accident. So it could be a tiny difference, could have huge consequences, right? That could be the case. But see how different it is if you are in another field. For example, the field of cancer. You're a researcher in cancer and you want to investigate a new chemotherapy. There already are existing chemotherapies, but you have a new one. I think you're not interested to see whether this new therapy is a smaller improvement than the other one. No, you want that if this is a good therapy, you want to make sure that this maybe gets rid of all the cancer cells, no side effects, etc. So then in a different field, what you're interested in might be completely different than another field. Also in psychology and law, that's the same thing. So, for example, when we asked fellow psychology researchers in our field and asked them, for example, about, okay, you are researchers in the field of false memory. So you do research in the area of that memory sometimes can be distorted. At which moment do you think that these memories are practically relevant? So we asked experts, I would say, and these are people who publish in this, and we could not find any consensus. Some said, well, if I do a study and I find a significant effect, then it's relevant. And some say, no, if one group has 10 more false memories than the other group, then I think it's relevant. So we don't find any consensus in our field when a study, when a finding is relevant. And why is it important, for example? It's important because of this, for example. This is a rather recent meta-analysis on the influence of alcohol on witness recall. So a very interesting meta-analysis in which they look at all previous studies that investigated what alcohol can do with your memory. And they found, for example, that alcohol indeed can impair memory. But they also said, well, it does not really impair the reporting of false details. And they only based their conclusion on statistical significance. And importantly, some of these colleagues, they are also involved in legal cases. And then if they're being asked, so does alcohol impair memory? Does it lead to the reporting of false details? They will say perhaps it does not lead to the reporting of false details. But when we looked at that meta-analysis, and we thought, when is something really practically relevant, we made an hypothesis. We made a certain smallest effect. We said, well, if you already incorrectly remember one detail, that might be a problem in a case. And I will give you some examples. I need people in court to have the same thing. If you incorrectly remember, let's say that I'm being attacked by Laura, and so she hits me now because she doesn't like my presentation. Well, possible, of course. And people are, and you're asked, by the police about what she has been wearing, and you don't know, many of you know Laura, but still you don't know Laura, and she said, well, she was wearing not this colorful dress, but she was wearing a black dress. It's a wrong detail. People might look for someone with maybe more a black dress and might apprehend you or someone else who has something black. So one detail could make a difference, right? So with that in mind, we thought, well, let's look at that. Let's look at that meta-analysis, and we found actually that the effects that they did find were practically relevant. They were practically relevant, and not saying that what we find relevant, others might disagree with that, which is perfectly fine. But I think it's important, if you are a psychologist and you're working or you're doing stuff maybe for society, to at least think about how meaningful the research is that you're using for societal purposes. So we recently have been doing some studies to examine what people find relevant. What do people find relevant in the field of memory? And you can do it in different ways. You can, for example, ask what we call stakeholders. These are people who work in the field, for example, judges or lawyers. So that's something that we recently did. Paul Rieshuis did that together with other colleagues, including me. And we just asked legal professionals how many details people should misremember in order for you to say that, for example, a testimony is not reliable. So we recruited legal professionals, defense lawyers, prosecutors, judges, and they were presented with some hypothetical scenarios about an unarmed robbery, and the legal professionals were asked, how many memory errors would you allow before taking certain legal actions? And we found that the majority viewed 1 to 3 memory errors as practically relevant. You can see that here, but it may be difficult to see. But on the x-axis you have memory errors, and these are the amount of legal professionals. So they said that somewhere between 1 and 3 errors would already be enough to take legal actions. Interestingly, most say I don't care how many memory errors. 1, 2, 20, I don't care. Okay, that's also interesting result. But also 1, 2, 3, and that comes a little bit close to our idea that 1 error might already be the difference. We just did a recent study. So I told you about Indonesia, so we go almost every year to Indonesia for my family, but last, when was it? February, we were in Indonesia again, also for research purposes, and we gave a talk to the Women and Children Center. This is some sort of child protective agency center who interview child witnesses, for example, who interview women who might have been abused, and they want to know what happens to them. And what did we do? We also asked them about how many errors in a children's testimony would you find problematic already? And we found a little bit the same effect, that especially 1, 2, 3, especially 1, they said 1 detail, if that would already be wrong, that would be a concern actually. And it is interesting because last Friday we organized a symposium in the Netherlands. I just talked to you about these police files that we are looking at, this very sensitive data. Why can we look at that? In the Netherlands there is this very unique committee that I think nowhere in the world exists. It's a committee in Dutch. Now, the English translation would be the Dutch Committee for Special Abuse Cases. So this is a committee that is involved in the investigation of a potential case. So for example, let's say you remember that you have been abused by your father, but you don't know where this memory comes from, but you suddenly remember this. You go to the police, and the police looks at that, and in these types of cases, in which you suddenly remember this, they first go to that expert committee, which consists of people from the police, legal psychologists. I was involved in that committee also, forensic psychologists, clinical psychologists, and they look at that case independently and decide whether the statement might be true or might even be false. And why is that committee there? It exists because of wrongful convictions that happened in the Netherlands, to prevent such wrongful convictions from happening. So in many of these cases, the committee says, well, could be reasons that this is a real statement, but there are also cases in which the committee says, I think this is a statement that might be wrong. And that's important because at that moment, the police will make sure that they will not apprehend the suspect then. Because I'm not sure I was in Romania, but also in the Netherlands, if you are apprehended by the police as a suspect, your rights will go down, and this is not an easy thing. And if you're then innocent, that means that's something that you of course don't want to have. So this is a way to prevent such errors in court. So why do I introduce this? Because this exists already since the 1990s, beginning 2000. So there are a lot of police files in there. And we now have the opportunity to examine these police files, together with people also from the police psychologists. And what did we find? That the misremembrance of one detail made a huge impact in these cases. So this is interesting because it shows that research that we do, which might generate one or more details, can be considered relevant in court. So what can we do? That's something I want to end because, yes, I'm talking too long. What can we do? How, if you're an expert witness, what should you do? If you're a psychologist working for society, this is just a simple guide. Let's say you are a psychologist and you're asked by someone, a legal professional who says, well, I have a person here, Susan, she has mental health problems. She goes to therapy. Therapist believes in repressed memories and suggests to Susan that her complaints are due to hidden traumas. Susan does not have any recollections, but gradually starts to recover these memories. Finally, she remembers being abused by her father. You, as a psychologist, are asked about the role of suggestion in the creation of false memories. So what you could do, what many maybe will do, is just based on your experience and your expertise, you will just write a report, not knowing maybe perfectly whether what you are writing is really relevant in this case. So I think what you should do, if you want, first see whether the stuff that you are doing, whether this has been replicated. And look at that. And look at Web of Science, for example, whether research on false memory has been replicated. And yes, this research has been replicated in many different areas. There are reviews. Look at whether the research that you want to use, whether people have said something about whether it's generalizable. You could do that on Web of Science or other search engines. Look whether people have talked about this, written something about it. Critically look at the papers that you're using in your report. And here are some examples in which researchers have indeed said something about generalization issues. Is the research practically relevant? Do scholars talk about this, yes or no? So a way forward that we said one way to do it is to look at whether our research indeed meets these conditions of replicability, generalizability, practical relevance. We recently did that for the Journal of Criminal Psychology for a special issue, and we had this coding scheme. And what was very interesting, I thought, is that we didn't have really super clear hypotheses, but although we did expect that not a lot of studies there were replicated, but what we did find is that the studies in that journal, compared to more experimental journals, used populations like people in prison, real victims, populations that you sometimes also see in real cases. So on the generalizability condition, this was a journal that published a lot of interesting articles on that aspect. And the question is then, is false memory ready to be used at this moment? We've been looking at a lot of different papers on, for example, therapy and false memory, and whether they meet all of these conditions of replicability and generalizability and relevance. We have the first results, but then you need to have time to write it up. We will see. So the conclusion and recommendations is if you do work as an expert witness, then maybe in your report, see whether it's possible to say something about this, whether your research that you cite has been replicated, say maybe something about generalizability and whether it's relevant. It doesn't have to be much, but you can write something about it. And in a recent report I was involved in, we indeed made, for example, we referred to some studies and said, well, these are studies which are meta-analyses, people have replicated it. But in other studies we said, well, there's only one study that has examined this, so that at least people in court might have confidence in the stuff that you write. They know a little bit more what you write. At least that's our hypothesis. Our hypothesis, if you are transparent about this, that hopefully people in court have more confidence or put more weight or less weight on your expert witness report. So if a certain phenomenon does not meet all three conditions, you can still report it, but discuss its limitations. It's better to be transparent about the limits than to oversell it, which is difficult also as a psychologist. Keep in mind that oftentimes psychologists are paid by lawyers or prosecutors or courts to do research, to do expert witness work. And although they say that they are doing independent judgment, I mean, if you get money, you might become biased, and that might influence the way you write reports. So it's important perhaps to have that in mind as well. I think it's important for our psychologists to think about these dimensions. They might improve the role of psychology in the courtroom. And with this, I want to end this talk. Thank you very much.